Hello, good afternoon to those who are joining. Thank you very much. We're just going to hold tight, wait a few more seconds just so everyone who is joining can join live. So bear with us. I'm sure many of you are like me, Alyssa and Safta, sat around as many fans as we can during this heat wave, which we are not particularly well coped for in this country.
Not our fan club, but real fans.
Absolutely, real fans.
No cold air. Yeah.
Yes. Well, we love to complain, don't we, about how cold it is, and then as soon as it gets hot, we'll say enough of that. So.
Exactly.
I think it's the British mentality. We always complain about something.
Yes, every chance.
Absolutely.
Right, I'm going to get started. Good afternoon, everyone, and welcome to Law 2021 Online. Family Law Shape the Debate, sponsored by our Family Wizard with me, James Evans, Alyssa da Costa-Waldman, and Safta Mahmood. In this live session, you can put your questions to Alyssa and Safta and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you are watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within the next few days, so please do keep an eye out for this. For those of you who don't know me, my name is James Evans. I'm the UK representative and professional liaison for our Family Wizard. My roles include educating judges, barristers, solicitors, mediators, mental health practitioners, all other family law professionals about the online tools that can be utilised to benefit and monitor parental communication in high conflict cases. Our Family Wizard offers divorced or separated parents a collection of web and mobile application-based tools to easily schedule parental responsibility, share important family information, manage expenses, and create an accurate, clear record of co-parenting communication. Working with parents on our Family Wizard, family law and mental health professionals can leverage its tools to oversee communication and facilitate successful parenting through family separation and divorce. Our Family Wizard is recommended regularly by family law and mental health professionals all across the courts in the UK, throughout the US and Canada, as well as Australia and New Zealand. It is my absolute pleasure today to introduce to you our two speakers. The first of those is Alyssa da Costa-Waldman. Alyssa is a practicing barrister at Newport Chambers in London. She specialises in financial remedy cases and is also an expert in cohabitation claims. She is a regular speaker on legal topics and an author. And during her career, Alyssa has contributed to Blackstone Civil Practice, co-authored Family and Matrimonial Law, solely authored Everything You Wanted to Know About Practicing Family Law in 2004, and last year contributed the chapter on Trust Law to Resolution's cohabitation book. Alyssa encourages and practices non-court dispute resolution methods as an experienced mediator, collaborative lawyer, and family law arbitrator. As part of the Law 2021 Online, Alyssa's sessions include parental alienation and acting for grandparents. Safta Mahmood has extensive experience in both practicing and teaching family and children law for over 27 years. Safta practices predominantly in children law proceedings alongside his lecturing and legal writing. He has been a continuous member of the Law Society Children Law Accredited Scheme for approximately 20 years and is both an assessor and an author, having written in various legal publications, including for the Law Society. He is a highly articulate and popular speaker who has a practical and pragmatic approach to his subject. As part of Law 2021 Online, Safta's sessions include children proceedings and domestic abuse, the fundamentals and key issues, and special guardianship order developments and relationship with adoption and child arrangement orders. So to kick us off, we will start by addressing some of the pre-submitted questions that we have been receiving from you. And the first of those is going to come to you, Safta, if you don't mind. And the question is this. How does the definition of a PD12J fit in with the definition of domestic abuse in the new Domestic Abuse Act of 2021?
Lovely. Well, thank you very much indeed, James, for the introduction. I'm very grateful to you for setting out the position. And what a delight to be here on this very sunny Tuesday afternoon in July. And let's hope it lasts. Let's hope it lasts for some time. So with this first question, how does the definition then of Practice Direction 12J fit in with the Domestic Abuse Act? Well, let me just start with Practice Direction 12J. That is contained, of course, within Part 12 of the Family Procedure Rules of 2010. It's the specific practice direction which looks at the interrelationship between domestic abuse and child arrangements. Child arrangements specifying living with, spending time with, or otherwise having contact with, both in private and public law cases. Now, when you look at Practice Direction 12J, you'll find that the definition of domestic abuse has changed a fair bit over the years. The most recent update was back in October 2017, on the 2nd of October. And that's where the then president of Family Division, Sir James Mumby, said that we've got to ensure that encompasses not just matters related to controlling and coercive behaviour, but also some of the matters related to culturally specific forms of domestic abuse, forced marriage, honour-based violence, marriage abandonment, which many immigration lawyers in particular will find that is sadly a very common but unnecessary feature of advice that they'll be giving. And also, like I say, some of the matters related to honour-based violence. Now, the new Domestic Abuse Act, which many of you will be familiar with, only got roller set not too long ago. In fact, it was 29th of April this year, so it's still hot off the press, so to speak. What the Act wants to do is, even though a lot of it's not yet implemented, is it wants to bring in its own almost unified definition of domestic abuse. And there's going to be a new definition under Section 1 of the Act, which is probably the obvious place to put it in. And even though the definition at first sight seems a little limited, and I'll tell you what it is, I think given case law and guidance and regulations, which we'll no doubt get, I think the definition and the expectations upon it will be certainly progress quite swiftly. But the definition, putting it simply under the Act, is this. It's domestic abuse is behaviour by person A towards person B if A and B are 16 years of age or over and are personally connected and are the behaviour is abusive in nature. Now, that's not too different from the current government definition, which we've had in any event. You've still got to be 16 or older.
Can I chip in?
Absolutely.
Right. What I was going to say is, I think the Act goes on and it further defines what is meant by abuse. And it is, I disagree with you that it's limited, because I think for once it's actually widening what counts as abuse, because one thing that's included and on which I've done a presentation is economic abuse.
Yes.
That has until now not actually been recognised. So I disagree with you that it's limited because we have that. And in addition, in terms of the question, where does Practice Direction 12J's definition sit in comparison to the Domestic Abuse Act?
Yes.
I think it's a kind of reasonably simple answer, because the rules are secondary legislation and the Act is primary legislation, right? So my answer would be that the Act, the Domestic Abuse Act, its definition overrides everything else because it's primary legislation, and what we've got in Practice Direction 12J is part of the rules, which are themselves secondary legislation. But you can disagree with me if you want.
Well, what I'd say to you is this. There is the definition of economic abuse. Economic abuse is there, but actually also just 2 weeks before the Act made law, they were also going to be bringing in the elements surrounding domestic abuse between persons who are actually carers. So as a childcare solicitor myself, I had cases where, say you've got a situation whereby you've got a family carer in a family household, and he or she is actually abusing, their child, for example, or an adult in that situation.
Yeah, it could be the elderly.
Yeah, absolutely. And that's where often we'll get cases where the Court of Protection, for example, is going to be involved. And it's disappointing that actually they could have taken that particular definition further, but it was actually dropped.
I agree with you.
Just a week before. I agree with you. I think economic abuse is there. But, and again, just to take your point on that, we've had financial abuse for a very long time. Now, the only agency I would say who has actually gone as far as defining what financial abuse is actually legal aid agency. Some years ago, in 2016, they said, look, to become eligible for public funding, you can rely upon financial abuse. They've given us some limited examples of what that is, such as text messages, emails, and so forth, to show that, one person is financially abusing another. So I think, it is taking a definition further. But what I would say is I would come back to the initial point, which is Section 1 does say as simply as domestic abuse is, you've got to be 16 or over, you have to be personally connected, and the behaviour is abusive. And I think they've left the word it being abusive generally wider than perhaps what people would have wanted. But that's where I think the case law is going to come in. And I think we're going to need in due course. But yes, the other point is this: Practice Direction 12J is a practice direction. It of course supplements the family procedure rules. Whether it's going to be repealed, we don't know at the moment. PD 12J is still there. There's the harm report, which some of you will be aware was available in June last year. There's obviously a lot of changes this year by the Court of Appeal surrounding the use of Scott schedules in private children cases.
Oh, absolutely.
I think Practice Direction 12J is definitely in need of reform. For a number of reasons.
The whole idea of Scott schedules, I mean, you have to ask yourself, how useful are they?
Yeah.
And the whole fact-finding thing.
Yes.
Because I'm sure we've all dealt with cases, and I have found myself in many cases dissuading both the parties and the judges from A, doing a fact-finding, and B, Scott schedules, because what they're doing, particularly in children cases, not just abuse cases, but children cases with abuse, what's happening is people are regurgitating historical material, which is totally contrary to where they're trying to go with Children Act proceedings. If what they're trying to do is, develop meaningful relationships or renew meaningful relationships with children, does regurgitating and rehashing all the historical stuff that caused the relationship breakdown really take us anywhere?
Exactly. And I mean, many of...
And sorry to interrupt, but it's also against the background of we're going to have, it will be law in the autumn, no fault divorce. So why are we looking at who's to blame between the parents with children proceedings?
That's right. Although they have put that back now, unfortunately, to next April now after all that.
Yeah,
and we all kind of knew that, didn't we? I think COVID's sadly got a lot to answer for, even bringing in the new law, But you're absolutely right. And Alyssa, you and I no doubt have had cases where sometimes we're acting for, say, dad. He wants contact, child arrangement, spending time with. Mothers, out of the blue, raising allegations of domestic abuse. Some cases obviously legit and genuine. Others, sadly, are exaggerated. And then what you find is she'll come up with allegations which are so historical. And you're thinking to yourself, but even when you say that this happened, you're still allowed him to see the children face to face.
I think that's the point. And I think we need to be very careful about saying, there's obviously people who embellish the truth, who will exaggerate, but there's an awful lot of people out there who are abused and for whom it is really serious and traumatic. We mustn't belittle that in any way. But we have to sort of look at when did these allegations happen, and as you rightly say, is the other person seeing the children? So if they're not a danger to the children, then clearly what's the merit in wasting court time, client's time and money in going through all these allegations? Is there another way? And I think that's what we as practitioners need to be looking at, if there is another way of dealing with those.
That's right. Fantastic. Thank you. Hopefully that answers that question, James. I don't know if it's...
It answers it and more, which I think is fantastic. And a reminder our attendees that if you do want to ask a question to Safta and Alyssa, please do pop it into the chat. You've got evidence now that they will delve deeply into any questions they ask and battle their opinions, which I think is really fantastic. So thank you. Alyssa, I'll come to you next if that's okay.
Yeah.
And we're going to ask more specifically about grandparents as per one of your works for the Law Online. Why would you say do grandparents have to obtain permission before applying for a CAO?
Well, first of all, it's the law. The Children Act provides that unless you're within one of the many exceptions that people would have seen in my presentation, grandparents have to ask for permission. And I think, without going back to sort of 1989 when the Children Act first came into force, why do this? Because I think there are all sorts of family relationships, and my goodness, as practitioners, we know how high emotions will run when there are family proceedings. I think the answer is it's the old floodgates argument, and you've got to draw the line somewhere. And, there are categories of people, parents specifically, who for obvious reasons don't need to ask permission to make an application about their own children. But clearly, the courts want to be very careful about what other family members do make applications. And speaking as a grandparent myself, happily and most blessed of 7 grandchildren, I really appreciate how important that relationship is between grandparents and grandchildren. But equally, I understand how difficult it can be when the parental relationship is sort of asunder, broken, and there are difficulties, and therefore it is important that the court is there as a filter to make sure it's appropriate for grandparents to make an application. And also, as I say, you have to draw the line somewhere. And if you didn't, how many other types of family relations would want to make applications in those circumstances where, is it aunts, is it uncles, cousins, nieces, nephews, how many other people would there be wanting to make those applications? So I think it is important. The law has to draw a line and say that, important though the grandparent relationship is, it's important to have that filter.
Listen, can I just maybe as a side issue, just kind of look at that? Because of course, you'll be familiar with, going back in time a bit, there was the 2009 Re-B decision, whereby the Supreme Court took the opportunity to remind us all as practitioners that, of course, there is no presumption in favour of a child being brought up by the birth family. I mean,
Absolutely.
That particular case,
no presumption at all.
that particular case was a grandmother who did a splendid job in looking after her 4-year-old granddaughter. Father said, well, look, I am more of a biological parent than you are because I'm the father and you're one removed. But of course, the Supreme Court said, well, actually, biology is merely a contributory factor. Now, with that in mind, and bearing in mind we've got the fact that grandmother would possibly need leave unless she comes under 10.4, 10.5, the children actually have applied for leave. Would you say that Re-B and really what's come out of Re-B perhaps is somewhat inconsistent with the Children Act? Do you feel the Children Act should follow suit?
Oh, no, I don't think it's inconsistent at all, because I think what it's looking at, I mean, if you go through the welfare checklist and you look at all the different elements of a child's welfare, what's important about the carer of a child, somebody can be the psychological parent, but not the biological parent. And, in that particular case, if he wasn't there, and as you say, grandma had done a splendid job, no on earth would a court change that status quo in any way. And they weren't saying that the child couldn't have a relationship with the father. It was about with whom should the child live. And if the child is well and happy and all the elements of the welfare checklist are satisfied by remaining with the grandmother, then why would you change that? And it really is important. It's about who cares for the children, who does the day-to-day stuff. And unfortunately, while many people, and I think this, particularly fathers, think, that biology holds great weight, unfortunately it doesn't. Because in the life of the child, from the point of view of the child, what's more important? Who provided the sperm or who does the day-to-day care?
Absolutely.
That's quite a good soundbite, isn't it?
Get that on a quote for you, Alyssa. No, I mean, I guess it's a very good point. And our family wizard, it's one of the most popular occurrences we see, actually, is the grandparent is the one that ends up doing some or most of the childcare in a situation where the parents can't or won't. And the grandparents needs to be the first one it falls onto. So it's important that they get that place found. Safta, next question for you. How does the notice period operate when seeking a special guardianship order?
Right. Okay. Thank you, James. So this is, of course, special guardianship orders. You'll all be familiar from the presentation that these are Section 14 of the Children Act. It's been around now for 15, 16 years. I remember when it was a bill. Quite scary, actually, showing my age, but there we are. In terms of the notice period, the way it works, and it's very much like Alyssa's comments in terms of do grandparents need leave? Similarly, for giving notice to a local authority to be in a position to even assess you as a potential special guardian, you need to give them notice. Now, ideally in writing, because as you can imagine, an oral notice, there's always that risk, isn't there? People will say, yes, I did give it. Local authority may say, no, you didn't. It's always best to get it in writing. But there was a case back in 2016, a VR case, which I have put in the presentation, that I was involved in at the time. And that particular case was one where the Court of Appeal took the view that if, for example, you are a grandmother and you don't come within Section 10.4 or 10.5 of the Children Act, so you haven't got that connection, that commitment, simply giving the local authority notice is not enough to make it incumbent upon them to assess you. And it's again the point that Alyssa was making, which is there needs to be almost a filtering process so that you haven't got somebody on the other side of the country, for example, who's thinking, I've never seen my grandson or granddaughter, but you know what, I'd like to become a special guardian. Why? Why should they even have the opportunity to be assessed in a situation where the assessment is very detailed? It's going to engage obviously a lot of limited resources on the part of the local authority. So that's why, again, it's very much a kind of filtering process to make sure that only those cases which have some merit can then be progressed through to the next stage. And like I say, VR was the decision on that in 2016 by the Court of Appeal, which has stood to good test for the last 15 odd years. Thank you.
Brilliant. No, it's a great example. Thank you. We've had a question come in from live from someone in the audience to both of you. And it's to what extent do you both agree that sometimes DV is raised by, this person says mother, it can be father, it's more of a mother. At what point can it be raised by mother to prevent contact and essentially waste the court's time, especially when contact may take place after the final hearing? Do you agree with that?
It's the question, do people raise it deliberately to try and avoid contact happening? Whoa, then we're in sort of we're almost into sort of parental alienation territory here, aren't we?
Yes.
Unfortunately, and I've only got sort of anecdotal evidence because I don't think there's any figures. First of all, you would have to ascertain, in order to give a proper answer, you'd have to ascertain the number of cases in which it's raised afterwards or before or whatever, the number of cases it's raised primarily to avoid contact taking place, and whether or not it's deliberate parental alienation. Unfortunately, a lot of the parental alienation that takes place is surprisingly inadvertent, and it's very complicated psychological issues. Women that feel deep hurt because of the relationship breakdown, and they don't actually have sufficient insight to understand that the way they're operating has the effect of an action. But to what extent is domestic violence raised? This is something I've been practicing just a bit longer than Safta, right? This is my first year. And unfortunately, throughout my career, I have seen, sadly, and I use the term not in any sort of derogatory sense, but there have been fashions in reasons not to allow contact. We've had implacable hostility, domestic violence, a lot. When I started in practice, there were a lot of allegations of sexual abuse.
Yes.
You would have the mother who would actually contact the local authority and say, my child's making some odd comments or touching themselves in a strange way. I think the father or the stepfather or whatever is sexually abusing them. And all of this was designed to avoid contact. And I think it's our job as practitioners at the beginning of a case to make it clear that, there is a presumption in favour of contact, unless there's a good reason not to, and to let mothers know what is the good reason not to. But in your case, that evidence doesn't apply, because, to try and stop them raising it at a later stage if it wasn't in existence when you first see them. And I think we do need, and we need to screen people and make sure that whatever allegations of TV are made, or I suppose we should call it DA, more fashionably and in line with the Act, that we screen appropriately so that we can make a judgment call as to whether that's genuine or not. And if not, we need to advise what will happen if that is regarded as an example of parental alienation. What can then happen to the mother if she doesn't enable contact to take place?
And that leads,
right.
it leads nicely on the list. So, one of the pre-submitted questions we got was, to what extent can parental alienation be resolved in mediation? I know you and I have spoken in lots of times about the benefits of mediation and in relation to parental alienation, but I thought that might be worth asking you now whilst you're on the topic.
Yeah, I would say it is surprising. There are many cases which we get them and we think, oh my goodness, this will never resolve in mediation. But actually, once the parties are appraised of what the outcomes could be if not resolved, then they're more amenable to mediation. And one of the things that I recommend in my presentation is child-inclusive mediation, because it's one thing for the parties to go into mediation with an experienced mediator to get them to try and agree and to see how even inadvertent behaviour can become alienation and operate in that way, and the effects it has not only on the parent who's missing the children, but on the children themselves. But equally, it's important for the children, provided they are sufficiently mature, to enter into child-inclusive mediation to let their voice be heard. That's the purpose of it. And the beauty of it is, the mediator treats everything with confidentiality unless the children say, we want you to take this message to our mum and dad. Which, the mediator, an experienced child-inclusive mediator, would have already had that conversation with the parents. You might like what you hear from your children.
Absolutely.
From your point of view, this might be bad news. You might not like it, but you need to hear it.
Yeah, absolutely.
And that is how I think, using child-inclusive mediation as well as regular mediation for the parents, that is how I think some of these parental alienation cases can actually be resolved. So I'm very optimistic about that.
Fantastic. And can I just add on to that, Lisa, because of course, that idea of child-inclusive mediation, it's an idea that is being progressed, of course. There's the private law program that many of us know about, the CAP, the Child Arrangements Program, Practice Direction 12B. And there is a private law working party which has been working behind the scenes for the last few years on this. One of the recommendations in there, interestingly, is when we have our FHEDRA, the First Hearing Dispute Resolution appointment, they want to have an idea where, if that hearing is in the afternoon, for example, they want to enable the child to actually come and speak to the judge in person in the morning, as long as, they're age 7 or older, they want to.
With AFCAS, usually with AFCAS. Absolutely. And that's where you're getting the child, involved. And also the other point, Alyssa, which is, absolutely spot on, is one of the issues that the president raised, Lord Justice McFarlane, in that case of V some years ago, is he said, and I use this quote all the time in court when lawyers are using allegations of abuse and saying we've got to list it for finding a fact, Lord Justice McFarlane said, even well-seasoned family lawyers need to go back in time to the year 2000 when the Court of Appeal said that just because there are allegations made of domestic abuse, it does not mean that you list this matter for finding a fact hearing. You need to go back to basics. Exactly. But we're talking about that now. That 20 odd years later, and I think you and I are definitely well seasoned. Over 2 decades later, what's been done about that?
Exactly.
We're still having that debate. We're still having that conversation.
Absolutely.
And I think that's great pity. We should be having more conversations about how to get more people into mediation and child-inclusive mediation to avoid all this stuff.
Yes, that's right.
Fortunately, we've got 2 fantastic practitioners like the both of you who are pushing for that change. So that's what we're hoping we'll see in the future. Safta, I'm going to come to you next.
Sure.
Do many parents consent to adoption of their children, or do they generally feel they have to demonstrate that they fought for their child?
Sure, thank you. Yes. Yeah. I suppose what this comes back to is when it comes to adoption, there's adoption, as you'll all be familiar with, is the most draconian order that can be made. And given it's a total legal transplant, of course, you are taking away parental responsibility from a parent and giving it entirely then to adopters. As a parent myself, as obviously various persons around the audience today, we can only imagine the heartache, we would feel if, if our children were to be placed for adoption. So, of course, when you're dealing with cases in court, my experience has been over the last 20, almost 30 years, is I've only had a handful of situations where a parent has, and it's been very, very reluctantly, a parent has actually thrown in the towel, so to speak, and they've said, you know what, I'm not going to fight this. It's in those situations where the judge will sometimes have a discussion with the client. Some of you will be familiar with without prejudice hearings like we sometimes have, the settlement conferences, which was an idea that started in Liverpool and it's been used around England and Wales. The idea that a judge will sometimes speak with, say, mother on her own with the lawyer in present and say, look, this is listed for a 5-day contested hearing. Now, I can let you have that hearing, but I can tell you now that if you put yourself through that, you're going to do yourself more harm, because I can tell you now, it's not going to make any difference. And your children are not going to love you any less if you say to me today that although I can't bring myself to agreeing to my baby being, or my son or daughter being placed for adoption, I would say that it's in their interest to do so. Now, even when you got a judge who's obviously a very, very experienced care judge who says that to a parent, you can imagine, can't you? Not many parents are going to be in a position to say, okay, fine, I'll throw the towel in. So I would say to you that I think, understandably, many parents will want to go through the process of, in their words, fighting for their children. They will go through contested hearings. They will go through turmoil of being cross-examined and being, criticized on sometimes matters that, to other people you may think, well, actually this happens to other people, but why am I being criticized? But I think that's because of the love that they show for their children. And of course, letting go has got to be one of the hardest things. Like I said, I've only had a handful of cases where parents have said, I don't want to contest, but not many at all.
That's great. That's great. Thank you, Safta. We've had another question come in live from someone in the audience, and I think it's probably in relation to a conversation we were previously having. Why would one make a separate application for a grandparent's permission to apply for a CAO when the same can be considered under the C100?
I think, quite interestingly, I have a case going on at the moment where I'm advising grandparents to make a separate application.
Okay.
Because she needs permission, and there have been issues in the past. It's quite interesting. Dad is currently thinking about making a variation application, and one of the issues in the case is his parent, who is considering making an application for permission. I think it's important to separate out parental stuff and grandparental stuff. And I think there are different, no, seriously.
Alyssa, is that a legal term, grandparents? No, I'm only kidding. Is that
no, I'm inventing it. I've created it, but thanks. I've just created that. No, because I think, it is important not to. It's very interesting, isn't it? Very often, for example, if you were doing a Talata case, you sometimes find yourself being asked to act for an adult child and their parents who've put money into a property. Yeah. And I'm always very wary of acting for both because of conflict of interest, interveners and a party.
Yes.
In some ways, this is similar because the grandparents' interests, and obviously the major interest here is the child or the children. But I think the grandparents' interests are often different and their reasons for doing it are different to those of the parents. So I think it is appropriate because they have to seek permission, unless there are circumstances where they're exempt from doing that. I think it's important to keep them separate, even though the likelihood is they could be heard together. Yes. Because it's all part and parcel of the same thing. So I wouldn't see if permission were granted, I wouldn't see a court having difficulty in putting, not conjoining. That's when it's different jurisdictions. What's the word I'm looking for, Safta?
Consolidation?
Consolidation.
Yeah.
Thank you. The heat's got to my brain. But yes, I would have no difficulty in a court consolidating those applications once permission had been granted.
Yeah.
But I think it's important that the court exercises its role of filter to make sure it's appropriate, and then considers hearing them together and consolidation.
No, absolutely. And also, you know, it's always been an interesting bugbear for me, actually, which is there is variation within courts, jurisdictions, in the sense that some courts will say, right, we want you to do a C2 first to seek leave. We'll hear that.
Yeah.
Then we'll let you do your C100 and do that. Whereas others will be happily accepting your C100. You tick the box and say, I want leave, and then they'd hear the substantive.
Yeah.
You know, and it makes you wonder which one's the correct one, of course.
Well, that's the problem. And I think we are 11 years down the road from the family procedure rules, which was intended to standardise procedure across all family courts.
Yes.
We still have individual practices from different courts up and down the country, as if they don't want to be straitjacketed into a procedure. They want a little bit of their own control. But we need some form of predictability and uniformity and continuity as to how to do these things. So, yeah, I agree with you. And I think, you know, the appropriate way is ask for leave, don't just do your C100. Because in a way, your C100 and ticking the box is sort of preemptive.
Exactly. I agree.
Because it's preemptive, I think it's a little bit cheeky.
I agree with you. It's almost preempting that, you know, the leave will be granted. Exactly.
Yeah,
that's right.
And I don't think anyone is in a position to second guess what the court's going to do, or think that by just doing that, the tick box bit, it's going to persuade the court, because I don't think it will. In fact, I think rather the contrary.
Yeah, no, absolutely.
So with the differences, just following on from that, with the differences between the parent stuff and the grandparent stuff, what difference, or does it make a difference if the child is already living with the grandparents?
Yeah, it would, because then they wouldn't have to. The grandparent wouldn't seek permission.
Sure.
They can go straight to making their application.
Yeah.
Brilliant. Well, thank you for clarifying that. Safta, I'll come to you next. What are the key differences that you would say between the exercise of PR in the case of a child arrangements order living with, or a special guardianship order?
Okay, lovely. Thank you. So, child arrangements orders living with, as you know, are the good old-fashioned residence orders, as we used to call them all those years ago. And there is certainly a difference between the PR under living with orders and, of course, SG orders. The legislation tells us that special guardianship orders are such that you can exercise parental responsibility to the exclusion of all other people with parental responsibility other than another special guardian. You know, that's what it says. The way I always describe the PR under an SG order is I deliberately don't use the word special, because I think it sends the wrong message. You know, that person's special over here. So I don't use that word, even though I know, you know, that's written in the order. I use the word elevated. So I say, look, the PR you've got is elevated to an extent, in a sense that you are allowed to make some decisions yourself without needing necessarily consent. And a good example is taking the child out of jurisdiction. Now, as a special guardian, you're allowed to take the child out of the jurisdiction of England or Wales without needing consent for up to 3 months, whereas as child arrangements living with, it's less than a month, technically. There's other provisions. I mean, the classic one that I've got at the moment going on is, what if you're a special guardian and you're looking after your grandson, and your grandson is somebody who you feel should be having the MMR vaccination, for example. Now, that's certainly the medical literature would say the judicial jurisprudence on this is MMR vaccinations are routine vaccinations. But because it's a private law application, there was a case back in December last year, H&M, which basically said that something like that should be by way of a specific issue application. Dad applied in that case, mother objected. In fact, Mr. Justice MacDonald, if I remember, found in favour of permitting it. But
interestingly, sorry, just to chip in, but interestingly, because this is going to come up,
yes,
I think he also said this will be relevant in relation to COVID.
Exactly. Yeah, of course. Exactly. That's right. So the question is, and I don't know the answer yet, but does the PR that one has under an SG order override say, mother and father's objection to the child having the MMR vaccination. Now, the legislation doesn't say that. So I would err on the side of caution. I would be saying to a special guardian, you know what, I think we should be applying for a specific issue order on this. And as Alyssa said, I thought the parents would be...
Absolutely agree with you on that.
Absolutely.
That's my advice.
Absolutely. And also, I thought the parents were very brave in going to the High Court back in December. I think it was 15th of December, that decision, where they said to the judge, they said, you know what, we're before you. The COVID vaccination has only become available the last 2 weeks. Since we're here, chances are in the future, our children are going to be wanting to go overseas. There's going to be transport issues. Are they going to be allowed to have a COVID vaccine? And I think the judge said, well, look, it's a bit premature to give you the decision today, but what I can say is this. If in the future COVID vaccines are going to be available for children, in the absence of any scientific, empirical, medical research, which would suggest that it is unsafe for children to have this, more likely than not, we'll probably sanction it. But again, I thought the court parents did the right thing by going for a specific issue on that.
Absolutely. You know, I just want to come back to you on the word special.
Sure.
Say elevated. No, I'm really interested in that because there is going to be. I was on some Twitter feed and I tweeted about lawyers' language and how we inadvertently, subconsciously, whatever it is, the way we use language and how we can inadvertently manipulate the outcomes, manipulate how our clients see things, do things, take our advice. You know, they see us as authoritative figures most of the time. And there is, someone's just started something called the Family Law Language Project.
Right.
Which I'm going to be involved in. And I'm going to take that special.
Yes.
I'm going to take that to the project because we do need to change a lot of the language we use and think about how it's received.
Yes.
I have to say, I don't know how you feel, but when they changed residence and contact to living with and spending time with, I find that a bit clumsy and a bit clunky.
Yeah, I agree entirely. And I don't think it's achieved the outcome they were hoping for.
And you still get clients, don't you, that talk about access and custody.
They do. I mean, that's it. I had a father who said, look, I want access. I said, we don't call it anymore. He said, sorry, I mean contact. I said, we don't call it that anymore. So, you know, what do you call it? And when I told him, he just, well, you can imagine, you know, he just looked at me blank face. And like you say, the family procedure rules have been in place now for over 10 years. Part 2 makes it very clear, you know, we are supposed to be using very simple language. You know, we're supposed to be getting rid of, you know, words like ex parte and everything and ancillary relief and everything else. But yet we're bringing in these new words, which are making matters even worse, I think. So, there is an element to that.
You're right about special guardian. Oh, I'm so special. I'm a special guardian. You know,
yeah, that's right. So, fantastic.
It's fascinating, and you know, our family was we specialise more in the language of the parents, and you've seen our tone meter. And
I love your tone meter.
It points the parent in the right direction of their tone, but perhaps we need to invent a tone meter for family law professionals.
Absolutely,
some of them for sure. Some of them, yeah.
Maybe one day. I'm going to come back to something you touched on earlier, Alyssa, talking about Scott schedules. Once the case is in court, should there be a Scott schedule in relation to the particulars of alienation?
Whoa, I think that is so difficult. There's a huge debate around this whole area at the moment. And the one thing I would say is if there are current allegations of alienation and a judge is effectively going to have a fact finding in order to decide whether it has occurred, because the judge has to make findings of fact on alienation in order to decide what happens next, then the Scott schedule can be helpful. But sadly, I have been dealing with a number of cases where something purportedly being a Scott schedule has been produced, and yet there is no particularity to the allegations. And it poses the question for me as a practitioner, and indeed for judges in a PTR, a pre-trial review, how on earth can they make findings of fact if the facts aren't set out.
Yes.
And I think we have to remind ourselves, if a Scotch schedule is appropriate, and even amid this whole debate, there may still be circumstances where it is appropriate because the allegations are extant, they're live, it's still going on, then, you know, one of the things that I would always advise clients is, if you're going to make these allegations, you need to be keeping a diary of what's going on or not going on. You need to, you know, remind yourself of more recent incidents of what you consider to be alienation, so that when you do a Scotch schedule, it's not just some airy-fairy, oh, she never lets me see the children. It has to be, on this day, at this time, I was due to see the children. 10 minutes before I was leaving, there was a phone call. I felt it was an excuse. This was the reason that was given. I didn't feel it was genuine. I later heard that my child was at a birthday party, but I could have taken them. You know, that kind of thing. Any sort of a Scotch schedule is really, to me, no different to any other pleading type document. And therefore, if you want the judge to make findings of facts, the pleading has to contain facts, dates, times, incidents with particularity.
And that's where something like our family wizard comes in useful, right?
Absolutely. Absolutely. Yeah, indeed. But, you know, I've had a number of cases where I've succeeded because of a lack of particularity on the part of the other side. I mean, it gives me no pleasure in winning those cases, because as we know, if we're dealing with children, there's no winners, or well, there's only losers, and it's generally children.
Yeah, that's exactly right.
No, you're absolutely right. And also, linked in with that, you've got you know, similarity between the Scotch schedules and committal applications.
Absolutely.
Because of course it's exactly the same point where, like yourself, Alyssa, I've dealt with some cases where we've sometimes got applications for committal thrown out because, you know, the application notice doesn't particularize verbatim, you know, the actual allegations when it's alleged that the person did not comply with the order. And with that in mind, Part 37 has been updated to reflect that there's apparently going to be a new application notice coming out in the next few weeks. So I think there's going to be a very heavy emphasis on all of us as lawyers, making sure we are pleading, you know,
absolutely.
fact.
And it is about pleading the facts. And that's what we need to remember, that even though this is not sort of like civil litigation, there's a similarity to that extent. There, you know, just because it's family, and so many people think, oh, it's family, it's airy-fairy on evidence and all of that. Well, it isn't. You know, you're not going to succeed unless you particularize properly.
Great.
That's great, thank you. Just for our listeners, we've got about 15 minutes left, so you do have questions you want to ask Alyssa, and Safta, please do fire them through. But Safta, I want to ask you a bit more about some of the details of the updated Domestic Abuse Act. So the question is, how will the issues surrounding the cross-examination by the respondent of an alleged victim as a fact-finding change under the Domestic Abuse Act of this year?
Okay, lovely. Well, I mean, this for me has got to be one of the most significant innovations under the Act. And also, as a lawyer, you know, I am pleased it's coming in, but I'm disappointed as well that it's taken so long. This is something that, you know, not only the previous president of Family Division, but the previous president prior to that, you know, has raised, you know, for the last 20 years. Finally, we're getting it. Finally, the Act has got roller centre, and this is coming in. The way it's going to work is this, to give you the kind of examples that Alyssa and I have been discussing so far. So let's say you've got this. Say I'm acting for mother. She's got the benefit of public funding. Father wants contact. He's applied for child arrangements, spending time with or otherwise having contact with. Mother's got the benefit of lawyer. She's got legal aid. Dad cannot satisfy the LASBO requirements, which is very, very unfortunate, but there we are, because LASBO sadly has very major limitations with it in terms of availability for funding for respondents. He's unable to afford lawyers. So that's where the judge is in a very difficult predicament, thinking, how am I going to let father test the evidence? Because of course he's got a right to a fair trial, Article 6 amongst other things. Some judges will say, well, father, I'm not going to let you cross-examine mother, because that is seen as a form of abuse in itself by challenging her on exactly the same points that she's raised against you as allegations of abuse, and this is going to be tantamount to further abuse. You've got Mr. Justice Hayden, for example, in a case of VA, who emphasised that the case of BP and PS in 2018, which said that. So what's the new act going to do? Well, basically, this provision is not in yet, but it will be. It will be. It's just a question of getting the commencement order in place. What would happen is this: if, an example I've been giving you, if father has been convicted or cautioned or charged with any specified offence, which they haven't yet defined, but my guess is it's going to be any offence against a person other than maybe common assault and battery. I think it'll probably be the similar kind of definition as what you have maybe when it comes to fostering and adoption, perhaps. But, you know, we won't know until we get the definition. So if he's been convicted or cautioned or charged with any of those offences, or if there's a protective injunction out against him, and it's got to be on notice as opposed to without notice. And I like that part because that avoids people abusing the system by getting without notice.
Absolutely.
Or if you haven't got any of those aspects, but the judge is satisfied, and this is a discretion the judge will apply. The judge is satisfied. If I allow him to cross-examine, is it going to affect the quality of the evidence that the mother will give? And is it going to cause a significant distress? And that's going to be a judgment call for the judge, you know, based on obviously the circumstances. And, you know, there will be some discretion there, of course. But if the judge is satisfied on any of those, he will be prohibited from cross-examining. Now, what will then happen? Well, at the moment, the judges will sometimes put the questioning to mother, which doesn't always work. Sometimes, as a solicitor, we may be instructed via 16.4 for us to put the questions to the mother, which puts us in a bit of a conflict situation.
Can I chip in?
Sure.
I think the difficulties have been where judges have put the questions, because it then brings the judge from the judgment seat down into the well of the court, acting as advocate, which is totally inappropriate and has Article 6 issues there.
Yes.
And then a lot of courts will invite the person who's cross-examining to write questions.
Yes.
And then the courts will read their questions. That's slightly different.
Yes.
But again, you know, do they read their questions? Do they temper the questions for the tone meter, their internal tone meter, if the questions aren't appropriate? So it's all created a lot of difficulty.
Of course it has.
We've dealt with it hitherto.
Of course. Absolutely.
I just think now, isn't it the case that the court can actually insist that funding is made available for someone to get a lawyer?
Well, that's just it. So what will happen is, so because of all those unsatisfactory situations, which they are, thankfully, it's now written in the legislation that if father is unable to get funding, which in those circumstances he won't, the Secretary of State is now going to be providing an advocate, funding for an advocate. Now, this isn't going to come from a legal aid agency. This is from the Ministry of Justice.
It's almost like a public defender service, isn't it?
It is. It's very much going to be along the same lines of what we have in criminal proceedings, section 36, 38. We'll have an advocate appointed, not to represent father. So you're not on the court record for him, but you're getting his questions and you're talking to him, and you're actually putting those questions to mother on his behalf. So it will give him an advocate for the purposes of testing the evidence, which is exactly what we needed. And my guess is we're probably going to have some...
We need legal aid back. That's the reality.
I agree.
It's not this. This is like plastering a broken leg. This is like putting an elastoplast on a broken leg. The reality is, this wouldn't be happening if we had legal aid.
The way it used to be in the 90s. Yes, absolutely. Absolutely. There is that.
For heaven's sake.
There is that. But I think this is a massive innovation, and we needed something, didn't we? So hopefully, as soon as we get the commencement order, we'll know when this part of the legislation will be in. My guess is we may have some kind of a rota system. So just like we have with police station work, criminal work, we may have a duty rota for family lawyers who will literally be going and doing these types of hearings. So you may see the likes of...
I can see that. I think you're right.
I mean, I joined the family law community, 3.5 years ago. And since day one of meeting family law professionals, everyone has said to me, why did they take away legal aid? When are they going to bring legal aid back? It seems that the changes come, but they come very slowly, and perhaps not necessarily at the right time. I was looking at trying to squeeze in another question, but with the time we've got left and the amount of detail we get from both of you, probably unlikely we'll have time for any more. But thank you so much. And as we said at the start, if you do have more questions, you can send them through to Solicitors Group. Thank you very much for everyone who has attended the Law 2021 online today. Family Law Shape the Debate, hosted by our Family Wizard. A huge thank you to both Alyssa and Safta. Alyssa, I think I'm seeing you possibly next week, the week after, for a picnic. And Safta,
I think you are. I think next week.
I think it's next week. And Safta, I'm sure we're going to be speaking about
no doubt
later in the year. So I'm really looking forward to seeing you both. Don't forget to join the Solicitors Group Law 2021 online community. They'll be on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. I know Alyssa and I are both extremely active on LinkedIn and Twitter to continue that conversation. So please do join us there. As I mentioned at the beginning, a recording of today's Q&A will be sent out by email within the next few days to each and every one of you. And there is still time to watch the pre-recorded content that Alyssa and Safta have kindly provided. The expiry date for that will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this session if you haven't already. To book that, just go to www.thesolicitorsgroup.co.uk, where you will also find the online exhibition, the exhibition page for our Family Wizard, where you'll find out more information on us too. The exhibition is open to anyone to visit, and if you have booked the entire event, you can claim your 1 hour free CPD session from the webinar catalogue, which is usually worth £35. You can also visit our exhibitor page, as I said, for more information about our Family Wizard and for my contact details if you'd like to find out more. Finally, a feedback form for the event will be sent out to each and every one of you after the event closes, and by completing this, you will receive your CPD certificate. That's it from us for today. Thank you again to Alyssa and Safta. I hope you all have a lovely day, and we'll catch up soon. Thank you very much.
Thank you. Bye for now.
Bye.